Let me mention that section 138 NI Act also applies to corporate bodies, including association of individuals. If a check drawn on behalf of a corporate body is dishonored, not only the body corporate, but every person who at the time of the drawing of the check was in charge of the body corporate and was responsible for the conduct of its business shall be deemed to be guilty of the offense unless it could be shown that the check in question was drawn without the person's knowledge and that he exercised all due diligence to prevent the drawing of the check. Having said that, let me come to the most disturbing feature of the check dishonor cases. Dear friends, as per 213th report of the Law Commission, there are more than 38 to 40 lakh check bounce cases pending in the courts across the country. You can easily imagine how significantly the check bounce cases contributing to the arrears and backlog of cases. There could be no two views on the issue that delay in disposal of check bounce cases adversely affects the trade and commerce. As such, it was felt to reduce the time taken to redress the check bounce cases. The legislature has taken a step in that direction by amending Chapter 17 of the Negotiable Instruments Act in the year 2002 and bringing section 143 to 147 in the said act. From the perusal of those sections, it appears that the amendment was intended to achieve speedy trial and provides for continuous day-to-day hearing of the case till its conclusion, and further stipulates that trial has to be completed within 6 months from the date of filing of the complaint, with a view to have speedy disposal of cases. Provisions have been made for service of summons through speed post and notified private couriers besides the normal process. The complainant was allowed to give evidence by affidavit. Provisions have also been made for compounding of the offences. Now, in order to resolve the grievances of the people relating to pendency of check dishonor cases, amendment has again been brought in the year 2018 to address the issue of undue delay in final resolution of check dishonor cases, to provide relief to the payee of dishonored checks, and to discourage frivolous and unnecessary litigation, which would save time and money. The amendment has been brought about in the Negotiable Instruments Act. The said amendment came into effect from 1st September 2018. The amendment was intended to strengthen the credibility of the check and to help trade and commerce. By the said amendment, a new section called Section 143A has been inserted, providing inter alia that the court trying an offence under Section 138 may order the drawee of the check to pay interim compensation to the complainant. It has been provided that the interim compensation shall not exceed 20% of the amount of the check. One more section has been added by the said amendment, that is Section 148, to provide that in an appeal by the drawer against conviction under Section 138, the appellate court may order the appellant to deposit such sum which shall be a minimum of 20% of the fine or compensation awarded by the trial court, provided that the amount payable under this subsection shall be in addition to any interim compensation paid by the appellant under Section 143A. The provision under Section 143A, order of interim compensation can be passed even without determining the guilt of the accused. So this is a complete departure from the earlier provisions, where even without determining the guilt, the compensation has been said to be payable. Secondly, it makes available the mechanism of recovery as if the interim compensation was arrears of land revenue. Therefore, the provisions of interim compensation and making it recoverable by way of arrears of land revenue, the drawer of the check has been exposed to the coercive methods of recovery of such interim compensation. Now let me point out that the Supreme Court, in the case of G. Raja versus Raj Surana, has held that the provisions of Section 143A would be prospective. As such, the cases which were not filed till 1st September 2018, the provisions of interim compensation under Section 143A would not be applicable to them. The Supreme Court has, on the other hand, held the provisions of Section 148, where the appellate court has been empowered to award interim compensation, has been held to be retrospective. So that so if the in the case of an appeal, even if the appeal has been filed after the 1st September 2018, the interim compensation could be ordered. Dear friends, the number of pending check bounce cases is no doubt worrisome to the courts. However, it is even more worrisome to the litigants. The inability of the courts to adjudicate these cases in a timely manner is a serious infringement of the fundamental rights of the litigants. The right to access justice is one that has been reaffirmed by the higher judiciary in India many times. The right to a speedy trial is also one that has been reiterated many times by the higher judiciary and has also been granted as a distinct fundamental right under the boundaries of Article 21 of the Constitution of India. The Supreme Court of India has laid down specific directions to the criminal courts for the expeditious disposal of cases falling under Section 138 of the NI Act in the case of Indian Bank Association versus Union of India. What is crucial in the check dishonor cases is that the court should follow the stipulated time for the disposal of cases as per the legislative provisions. It is also important that the banks put in place mechanism that will reduce the number of disputes and help in identifying defaulters more easily. One step that could be taken by the banks is to create a master register on the lines of the France and debar the defaulters of check from issuing further check for the further period of 5 years. Therefore, what is most important is that something must be done to reduce the pendency of the check bounce cases, and the check bounce cases should be disposed of in the normal time provided in the act. Otherwise, the check would remain a promise to pay, but the payments would never be realized. With these words, I stop here. Pleasure talking to you. Thank you all for giving me a patient hearing. Thanks to the organizers once again for giving me this opportunity. Thank you.